Good evening, everybody, and welcome to the final webinar in our webinar series. For those of you that have tuned in previously, you'll know the setup. We will have a solicitor talking you through a slideshow that they've pre-prepared and setting out all of the relevant law for you. Tonight, you are graced with our Principal and Director Solicitor, Melinda Nettleton, and she is going to be talking you through disability discrimination claims in education. As I said, this is the last webinar in this current series. They've been really popular, so we are hoping to do another series in the future. So for those of you that have been in touch to give us ideas and topics that you might like covered, please do keep in touch with us. You can connect with us through social media, you can call up the office, however is best for you, but we'd be really delighted to hear from you so that we can make sure that the content is as relevant to you as absolutely possible. So if you do want to access our webinars at any time, they are all recorded and are available through links on our social media. You can also find them on our webpage, that's senlegal.co.uk, under the resources tab, and you'll also find all of our newsletters on there as well for those of you who prefer something in writing. So without further ado, I think it's time to hand over to you, Melinda. If you would like to start off teaching these good people everything they might need to know about bringing a disability discrimination claim.
The Equality Act is a really big piece of legislation. It covers so many things. It covers sex discrimination. It covers obviously disability discrimination. It covers racial discrimination, discrimination in maternity, but because it is so complex in terms of the areas it covers, there are a lot of pitfalls, and just picking out the threads that are appropriate to you is not always necessarily obvious. In these slides, all references are to the Equality Act and nothing else, unless I tell you otherwise. The Equality Act 2010 applies to local authority maintained schools, academies, free schools, independent fee-paying schools, further education, and universities. So covers the whole of education. What you've got to bear in mind as a starting point is that Section 6 defines disability, and not all special needs are disabilities. They are not the same thing at all. Section 6 defines a disability as a mental or physical impairment which has a long-term effect on carrying out normal day-to-day activities. So it's not a here today, gone tomorrow thing. It excludes seasonal and mild impairments. For example, hay fever is seasonal. Things which don't have a long-term effect on your day-to-day activities. The other point about disability discrimination is the responsible body, whether it's the school, the university, they must have been informed of the disability. You must have told them. If you're going to start proceedings for disability discrimination, it's called a claim. It's called a claim whether you start it in the county court or you start it in the SEND Tribunal. Claims must be made, that's to say started, in the SEND Tribunal within 6 months of the last incident of disability discrimination. Ideally, the whole of the disability discrimination you're complaining about will be within the last 6 months. Each act or omission will be individually considered in terms of the time limit by the adjudicating body, be it the SEND Tribunal or the county court. And in terms of that 6-month time limit, there is a reluctance to consider anything outside the 6-month time limit. You can go outside the 6-month time limit, but if you are going to argue you've got a continuing course of conduct to the present day, you need to be aware that this can be a difficult argument and you will need a very good explanation. One of the things we have as a practice is calls coming in, and somebody who's been actually upset and stewing on an issue for 18 months, 2.5 years. Sorry, but in most cases, you have left it far too late. Okay, so don't leave it, get on with it. If you're going to do something, be aware that after 6 months from the incident you're complaining of, you're likely to be saying goodbye to your case. There are exceptions, but you need to get it in within the 6-month limit, the very last incident. Telling me 18 months on is just not a starter. So what's covered? Well, the provisions governing schools, FE colleges and universities are different. Section 85 is schools, and sections 91 and 92 are further education and colleges, but they are to some extent a mirror image. They must not discriminate in the admission arrangements, the way education is provided, access to benefits or facilities, or by excluding. And in addition, because FE colleges and universities award grades and qualifications, they mustn't discriminate in that either. Although having said that, academic judgment is not covered. The adjudicating tribunal must have regard to the code of practice. This was issued under section 14 of the Equality Act 2006, which was a predecessor piece of legislation to the current Equality Act, which is 2010. Right, now let's go to the actual sections which cover disability. I have deliberately left out section 13 because for discrimination in education, it really doesn't help you. And if you are actually trying to, for example, argue discrimination in a special school, you're shooting yourself in the foot. Don't do it. So three sections you should look at. The first one is section 15, direct discrimination. That is unfavourable treatment as a consequence of disability. Unfavourable treatment as a consequence of a disability is disability discrimination. No comparators, no complicated bits, just unfavourable treatment as a consequence of disability. Potential defences, because there are defences. The treatment that has been meted out to a disabled person is a proportionate means of achieving a legitimate aim. And of course, in this COVID climate, a lot of things are happening which will, of course, be argued to be a proportionate means of achieving a legitimate aim. Whether it is or it isn't is going to be a question of fact or degree, but that is the potential defence to a section 15 direct disability discrimination. The other defence, of course, is that they didn't know about the disability. The second way you can prove disability discrimination is indirect discrimination. That is section 19 of the Equality Act. That is the application of a provision, criterion, or practice which is discriminating in relation to disability. So you've got to be able to prove there was a provision, a criteria, or a practice which has discriminated. Okay, so if it's not direct discrimination, is there a provision, criteria, or practice? Now, it is discriminatory if the provision, criterion, or practice would apply to those who aren't disabled, but puts the disabled person at a particular disadvantage. Okay, for example, if you have got a college which in obviously further education who says, well, okay, we have a policy of admitting students who are able to manage on their own, and your particular disabled person needs support, then that would be a provision, criteria or practice, the policy. And so you would have got through the door of section 19. The potential defence, again, is the provision, criteria or practice is a proportionate means of achieving a legitimate aim. And of course, they've got to know there's a disability as well. Okay, so that's section 19. Shall we move on now to the third ground in education, which is the duty to make reasonable adjustments. The duty to make reasonable adjustments, obviously you've got to have a disability, has 3 requirements. Firstly, the provision, criteria or practice put a disabled person at a substantial disadvantage. And if it puts them at a substantial disadvantage, then the school, college, what have you, university, has to take reasonable steps to avoid the disadvantage. The obligation to take reasonable steps overrides everything else. The second ground and the second requirement is where a feature creates a substantial disadvantage. There is an obligation to take reasonable steps to avoid that disadvantage. So, for example, if there's no disabled changing room, there's got to be one. The catch there is it doesn't apply to schools. Okay. So if there is no lifting, hoisting and all the rest of it, and the building needs altering to put that in, you can't say to a school, duty to make reasonable adjustments. You can say it to a university or FE college, but not to a school. The third requirement is where the absence of an auxiliary aid creates a substantial disadvantage. The school, college, university, independent school, free school, academy have to take reasonable steps to provide the auxiliary aid. And there's some interesting follow-ups on that one. The follow-ups on that one is they can't make the disabled person pay. No requirement to pay, it has to be provided for free. The term auxiliary aid, that's section 2011, includes an auxiliary service. So what that means is that if it requires people to make the reasonable adjustments and you need help, that person has got to be provided and provided for free. And section 21 says failure to make reasonable adjustments is disability discrimination. Of course, there is the question of, well, what is reasonable? And of course, that is a matter of fact and degree. If it really isn't going to cost much and is terribly easy to do, then the organisation isn't going to have a leg to stand on. It's a question of fact and degree at the end of the day. Okay, so where should your claim for disability discrimination be made? It's not straightforward. Nothing under the Equality Act is straightforward because it covers so much. So there is the SEND Tribunal, that's Schedule 17, that says it's the SEND Tribunal for schools. The schools, including maintained schools, that's local authority schools, free schools, academies, and independent fee-paying schools. Nurseries, if they are attached and part of a school. Not if they're completely freestanding and not part of a school. Okay, so let's contrast that with the county court. You go to the county court's the square on the opposite side, for FE colleges, universities, organisations using school premises, for example, if someone hires the hall, and nurseries not attached to schools. Claims in the SEND Tribunal and the County Court must both be within 6 months for the last incident. Ideally, the whole lot within 6 months. You can go longer than 6 months, but there must be a good explanation and a link. The compensation situation is very different. There is no compensation orders possible in the SEND Tribunal. Schedule 17, subsection 3B, for those of you who want to look it up. In the county court, however, compensation is orderable. In the SEND Tribunal, no costs, apart from in exceptional cases. In 2013, we had an exceptional case and a 5-day hearing against an independent school, and the parent obtained £86,000 costs back in our case. But that was a seriously exceptional case. So compensation in the county court, costs in the county court, no compensation in the tribunal, normally no costs or compensation in the tribunal. However, the SEND Tribunal has the advantage of being an expert body in its own right. And its case management is, frankly, a great deal better than the county court in these cases. In the county court, because you've got a generic county court judge, the county court judge sits with a trained assessor. The trained assessor is not there to assist you. The trained assessor is there to provide advice to the judge. When you have cases in the county court, you quite often will have solicitors on the other side, and they won't actually know that. That is an important point to remember. It affects how the case is listed. Now, whilst I've explained in general terms, there is no claim for compensation in the SEND Tribunal, it doesn't mean to say that the SEND Tribunal decision in disability discrimination cases is valueless. In independent school cases, it is very valuable indeed. And because universities and FE colleges are also based on contract, a finding would be very useful indeed. And I'll explain why in relation to those two later. Now, the reason the tribunal decision is useful in cases involving independent schools is that the Consumer Rights Act 2015 requires services to be performed with reasonable care and skill. Education is a service, and educational services in independent schools are based on contract. What that actually means is that under the Consumer Rights Act, if you have got a finding of disability discrimination by the Sendis, it is almost impossible for the school, that's to say the responsible body as the disability discrimination provisions call it, it is almost impossible for the responsible body to argue that the contract for educational services has been performed with reasonable care and skill. It is effectively a finding of a breach of contract. Yes, I know that when it comes to a claim in the county court for your money back and compensation, some firms and solicitors will try and argue otherwise, but we've never had one that succeeded. So you can claim your school fees back in the county court because of the breach of contract, not performance with reasonable care and skill. You aren't necessarily going to get school fees back right the way to when the child joined the school. Certainly if it's a 2 or 2.5 year GCSE course, you can in fact go for that, and I've certainly settled for that sort of money back. Household insurance is an issue that comes up. Some parents say, well, we've got legal expenses insurance. If you've got legal expenses insurance, certainly consumer contracts under the Consumer Rights Act are likely to be covered. You do need to look at the policy, though, the wording of the policy very carefully. Insurers like to use their own panel solicitors. The problem with that is that their own panel solicitors are not likely to have had a specialist firm involved that has actually taken a case through the SEND tribunal and then onto the county court. Equally, they might actually say, okay, we've got to be consulted before proceedings are launched, which in view of the short timescale is not always possible in terms of insurers. The Financial Services Ombudsman has agreed that a parent may choose their own solicitor if for some reason there are exceptional circumstances. For example, the case is complex. We have succeeded in that. We've also succeeded via the Financial Services Ombudsman in putting in proceedings and then going through the rigmarole with the insurance company. So it is possible to do it. It is possible to do it on your insurance. We have done it. Okay, I hope that helps if you've been paying independent school fees. Compensation for disability discrimination. Now that is a separate issue to compensation for breach of contract. It's under the Consumer Rights Act. That is a separate issue to compensation for negligence, because it is possible to sue in negligence if you've got disability discrimination claim finding, and we have done that. So negligence, the amount is bigger. Anyway, straight up compensation in the county court for disability discrimination. Depends on the individual facts of the case. It can include injury to feelings as well as financial loss. That's to say your school fees or negligence and the injury to feelings. If there is no provable financial loss, you're stuck with the Vento bans. Vento was a case. They are updated annually in April. We obviously have got a new update coming up. And as of April 2020, the most serious upper band is 27 to 45,000. Okay. Cases that do not merit an award in the upper band are 9,000 to 27,000. And less serious cases, the one-off incidents, are the lower band, 900 to 9,000 pounds. Drafting your Equality Act claim. If you're going to do it yourself, this is how you draft it. You need to present your allegations in the context of the statutory duties to pupils and students, quoting the Equality Act, Section 85 for schools, Section 91 for further education, colleges and universities, and how the sections apply. So, for example, if it's reasonable adjustments, well, what reasonable adjustments weren't made? Why should they have been made? That sort of thing. So you number your paragraphs and you double space between the paragraphs in your claim. And that is basically how you draft. You can find the text of the sections I've been referring to in the Equality Act by clicking on WW legislation, and you should look closely at the wording when drafting. And you will need evidence that the school, FE college, university knew of the pupil or student's disability. If you are submitting a claim for disability discrimination in the SEND tribunal, the procedure is very similar to other SEND appeals. I put there the name of the rules that apply in the SEND tribunal. It's the tribunal procedure brackets first tier tribunal health and social care rules. If you enter that in, if you Google that and WW legislation comes up, you've got them. Okay, what you're going to need is a disability discrimination claim form. It's SEND form A if you're a parent and SEND form B if you're a young person. You will need evidence of your diagnosis, and if it's not obvious from your diagnosis, it's serious, long-term and affecting you over the long term and everyday aspects of life, then you're going to need evidence of supporting evidence of that. You will need other supporting evidence. You need to put in other supporting evidence of your claim, for example, emails, to demonstrate what the responsible body has done wrong. And you need your reasons for claim. If the young person is over 16, you will need to provide an explanation as to why you as a parent are trying to run the claim and why the young person can't make their own claim. It may be fairly simple. The young person is not capable of running their own affairs due to their lack of understanding. For example, it may be the sort of case where ultimately you would be going for a deputyship in the Court of Protection. On the other hand, if the young person is a high-functioning ASD case or high-functioning dyslexic, but the young person doesn't feel up to running their own case, then you need a short letter appointing you to conduct the case. And that should go in with your claim. When the claim has been registered, that amounts to entering it on the tribunal's computer, you will receive a letter from the tribunal giving you the claim number, that's your case number, a date by which the responsible body, that's the school, must provide a written response to your claim, a date for final evidence to be provided by both parties, and a date by which the hearing bundle must be provided. You will be given a hearing date, you will be given an attendance form, and you will be given some case management directions, which may include participation by both parties in a telephone case management hearing with the judge. In the case of a school, you will find you are most likely not to be dealing direct with the school, but with the school's lawyers by that point. That is because any professional body with a reputation to lose will normally appoint solicitors. So you are likely to find yourself with solicitors on the other side. Now let's turn to submitting your claim of disability discrimination in the county court. Despite the fact that it is a claim for disability discrimination, you send it off to the county court money claims centre. You fill out a claim form N1, and you also fill out a form N235. That's a certificate of suitability of a litigation friend if the disabled person cannot run their own case. That is similar to the explanation you give the tribunal as to why the young person can't do it if they're over 16. So there is that particular issue. The other issue is that it's relevant to costs, that courts don't normally award costs against litigation friends. The costs, if they're going to be awarded, are against the young person. And if the young person has got no means at all, then the court is going to be very, very reluctant to make a silly order. So whilst you will find that there are a lot of hissing from lawyers on the other side, and they will be appointed by anybody that's got a reputation to lose, lots of hissing designed to put you off from running a case, you need to bear in mind that there are big limitations on what costs will be awarded. So that is the implication of the certificate of suitability of a litigation friend. It has a cost implication as well as who's going to manage the case. You will need to submit particulars of claim, that is to say what happened, why you think it's unlawful, the kind of order you want to resolve the problem. Exactly the same as I've already gone through. That's just a summary. Double space, number the paragraphs. You want to, in the county court, you want a list of exhibits. You want your actual exhibits, not just a list, what you're actually referring to. And you're going to have to give them the court fee, because there's a court fee to start it off. There is no comparable court fee in the SEND tribunal. That's another difference between the two systems. Okay, so next steps in the county court. The other side, that's to say the school, the university, the college, normally files a defence. And if there is no defence filed, you can ask for judgment in default. The court will issue an allocation questionnaire. Remember to put on the allocation questionnaire that an assessor is required to sit with the judge, because that will affect the allocation. And the chances are the solicitors under the other side won't know that. Under the civil procedure rules, you have, under the civil procedure rules, you have an opportunity to put in your reply to the defence, but after that reply to the defence, nothing else can be submitted without the court's permission. That's Rule 5.8 of the civil procedure rules. The court is likely to provide directions, well, it almost certainly will, and it may be on paper, or it may be a live hearing. And the judge will indicate either on paper or in a live hearing, and nowadays they tend to be video link, what actions the parties should take and set dates. A directions hearing is not about the merits of the case, it's about who does what and when. And the judge's instructions are called directions, and that's why it's a directions hearing. At the hearing itself, as I've already mentioned, the judge sits with a trained assessor. The assessor's role is to assist the judge and not the parties. Rule 35, incidentally, states the assessor's costs form part of the costs in the claim. And as I've already explained, in the county court, the rule is the winner gets their costs paid by the other side. And the other side, of course, will make a lot of noise about how expensive they are going to be, designed purely to put you off and make you abandon the claim. If you are the litigation friend and you're the comparatively wealthy parents, let's say you've got an income, whereas of course the young person won't have, you need, as I've already said, to be aware that costs are not normally awarded against litigation friends unless you've behaved really dreadfully in some way. And the court doesn't make silly awards against people with no means, they just make themselves look ridiculous. So you don't necessarily have to be desperately worried about claims for costs. They are a part of the normal litigation chess beating.
Well, thanks very much for that, Melinda. That was really, really helpful, actually, and very, very well explained. So hopefully that will have been really, really useful to everybody that's logged in to pick up some information about disability discrimination claims. Obviously, as this is a pre-recorded webinar rather than live, we have reached out through social media to get questions that parents want answered, which I can now put to you. If you please. So there are a couple of questions about comparators, and quite a few of them have quite a few arms, so I will go through them in detail. So the first question that we received in requested some clarity about bringing a disability discrimination claim when the child is attending a special school. So the example they've given is where possibly all of the children are under a disability, but the nature of those disabilities may differ. So, for example, in a case of indirect discrimination, what would the persons with whom B does not share the characteristic be? Would those be pupils who don't have a disability at all, or would they be pupils who don't share the same disability as the child who's subject to the claim?
Right. The answer to that one is don't use section 13 and you won't have to bother with comparators. If you don't use section 13, you haven't got any problem at all with comparators. You should be using section 15 or section 20. The whole idea of looking at section 6.3, looking at comparators is just completely misplaced in a special school. And if you're looking at comparators, you've got the wrong section. Go to section 15, that's where you should have brought it, or section 20, or even section 19. But you really, really should steer clear of section 13. It is of limited use to anybody in the education sector. Forget it.
This next question actually relates to evidence and what evidence might be satisfactory in a disability discrimination claim. So the question itself is how much evidence, particularly medical, would satisfy a judge that somebody is disabled as defined by the Equality Act? And their specific question is, can partially redacted letters be submitted? And that's based on a concern about disclosing information that would obviously lead the judge to determine that a young person or child is disabled without causing embarrassment to the disabled young person. Do you have any advice on that?
Yes, go and read section 6. If you read section 6, it defines a disability as a mental or physical impairment. So what is the medical evidence of a mental or physical impairment? We should be looking at medical evidence to establish that and putting that into the tribunal. And what is the evidence that it has a substantial and long-term effect on carrying out normal day-to-day activities? I would normally expect that to be covered by the medical evidence or be completely self-evident from the actual diagnosis. So worrying about emails which are potentially embarrassing is they are not there to prove disability. It's not how you do it.
Okay. And we have a question now about the timescales to bring a disability discrimination claim. Specifically, does the 6 months run from the first or the last event or incident?
The last possible date is 6 months from the last incident. So if, for example, the incident has happened, the parent is stewing, we quite often sometimes get them with days to go. On the other hand, we also get them 18 months down the line because they've been upset for a very long time. If you're going then beyond into the period before the last 6 months, you have got to have a very, very good explanation because they will be reluctant to go there.
Okay, thanks very much. This is quite a hot topic, actually, this next question, because we've been seeing quite a lot about this on Twitter. So this parent has asked, can you take a local authority to the SEN Tribunal for disability discrimination? The SEND Tribunal website does now state on it that they handle appeals relating to discrimination by schools or local authorities due to a child's disability. But this parent has been told you can only take cases against schools to Sendis.
It's schools only. The website's wrong if that's what it says. The reason it's schools only is Schedule 17, paragraphs 1 and 3. And anything else is the county court, which from memory, I think is a section 114. But bearing in mind I'm dyslexic, I get numbers muddled up. It could always be a section 141. But I think it's 114, but it's definitely Schedule 17 that makes it clear it's schools only.
Just a side note for everybody listening, actually, the HMCTS and Tribunal's website and the forms are not actually written and maintained by the courts and tribunal services. They are done by an external body, and they've obviously made a clanger there and have put the wrong information in, we will flag it up to the tribunal at the next user group. But I just think that really hammers home the importance of checking legal advice with qualified people, just because even the court's own forms and information can be inaccurate from time to time. There's a lot about that on Twitter at the moment, and hopefully that just clarifies the position for people.
It is a really complex piece of legislation, though, because there's so many schedules, because it's covering so much.
Absolutely. And then this final question, Melinda, actually there are lots and lots of questions about this subject, so we've sort of amalgamated it into one. And they are asking for any examples of remedies that you may get in Sendis other than an apology.
The Sendis can actually make all sorts of recommendations, but I think the most comprehensive one I have ever seen is the Sendis case against Stanbridge Earls School, which we did a few years ago. It's a reported decision. I've already mentioned the fact that the parent got £86,000 costs against the tribunal, and subsequently we ran a claim in the county court after the decision for compensation and got considerably more than the Vento bans. But the order in that case, I will read it to you for an example of just how comprehensive and wide-ranging the SEND tribunal powers are. The order in that case, after finding the responsible body, Stanbridge Earls School, had discriminated, said, first of all, that the decision was to be edited to remove the name of the young victim and her parents, and was to be sent to the Secretary of State for Education to consider whether the registration of the school, Stanbridge Earls School, continued to be justified. Bear in mind the school eventually closed. It also said that a copy of the decision was to be sent to Ofsted by the school. So it then had Ofsted breathing down its neck. It then ordered the responsible body, the school, to send a copy of the decision to each local authority which had named the school. It was in a statement of special educational needs, but that's now Section I of the EHC plan. So a copy of the decision went to every local authority, and as you can imagine, a lot of local authorities promptly withdrew their pupils. And a copy of it also had to be sent to the Director of Children's Services in the county in which the school was situated, which was Hampshire. The tribunal then ordered the responsible body, the school, to act on the advice of to instruct a suitably qualified equalities trainer with experience in disability to advise them, and also to ensure that staff and governors were appropriately trained under their duties in the Equality Act, and to ensure all of their policies and procedures were fully reviewed. Well, that would apply to any school. They could do that. The responsible body was also ordered to obtain and act on the advice of a suitably qualified ASD trainer in order to ensure the staff and governors were appropriately trained and adjustments were made for pupils with ASD. They carried on with the decision and required the standard apology. And then in addition to that, the case received a heck of a lot of publicity in the national press. And it wasn't that long afterwards when the school ceased to be viable and closed. So you have to bear in mind that whilst the SEND tribunal may not have powers to compensate a parent, the effect on a school can be quite serious. And whilst that case was a few years ago now, it is not forgotten by any means. One of the reasons why They go running off and getting teams of lawyers whenever anybody starts talking about the Equality Act. I'm afraid it's why you will find lawyers on the other side in any proceedings, whether they are in the SEND tribunal or in the county court.
So quite a wide range of different remedies there, Melinda. I've just got a quick question that I'd like to add on the subject of apologies, because that's something that we get quite a lot over the phones when people call in for advice. When it comes to the apology, is there anything parents should be looking out for? Are they able to insist on particular wording for an apology?
Only if it's in the order, and some of them are downright grudging.
Okay, I think that's the basis. Yeah, sorry.
Yeah, some of them are downright grudging.
Yeah.
And you have difficulty in believing they are seriously meant.
Mm-hmm.
You've got other orders in there, like training, like altering your policies, and a whole load of bad publicity. That's what hurts. It's not the apology.
Well, that is all of the questions, Melinda. Thanks so much for running through all of those. Hopefully that puts the flesh on the bones of the presentation and follows up for everybody that had questions to ask. Thank you so much to everybody who sent in questions, both for this webinar and all of the other ones we've run. The engagement from parents and from schools has been absolutely fabulous. We've all really, really enjoyed speaking with you and working with you and answering all of your questions, and really, really hope to do so again in future. So just to reiterate, to make these as helpful for you as they can possibly be, please don't be shy about speaking with us about what you want to know and what would be helpful to you, because there's no point us doing all this content for you if we're teaching you to suck eggs. So that brings an end to our webinar series, and thank you everyone so much for watching.